Thank you, Ms. Noble. On Section 4, page 4 of your bill, starting in sub C, starting in sub C, your legislation states that a defendant in this case, in any of these causes of actions, a defendant may not use Rule 91A of the Texas Rules of Civil Procedure. Are you aware that what that rule does?
He's wondering if I'm aware of what this rule does. I'm going to have to just say no advised. I'm not advised.
Okay. You do know that rule in the Texas Rule of Civil Procedure is called the dismissal of baseless causes of action. Correct?
Not advised.
Okay. So, I'm sorry, you're not sure or you don't know?
I'm not looking at that part of the code.
Okay. So, Rule 91A, it says that the court may not award attorney's costs or attorney's fees under Rule 91A. 91A says that if somebody files a frivolous lawsuit, a baseless lawsuit, that means that there's no rhyme or reason why they should be filing it, that the AG or the person that's allowed to do this can just...
You do realize that the amendment we just adopted narrowed it down to just the AG?
Yes, correct.
You do understand that correctly? Correct. Okay.
And you understand that the AG in this statute, in the existing statute, the AG has the ability to recover costs. Correct?
I am not advised in that statute. I'm not reading that statute as you are.
No, not Texas Rule of Civil Procedure. Literally the statute that you are amending right now. Section 2273.004 of the Government Code.
Yes. Our goal, of course, is not to have any action. Our goal is to have cities not doing this, and therefore there is no need for a cause of action.
Yes, of course. And in the existing law of that statute that we have already put in place many sessions ago, the existing law provides the Attorney General with the ability to recover court costs. You're aware of that?
Correct.
Okay. But on the flip side, you're now purposely denying the city the ability to recover court costs for a frivolous suit, even for a frivolous suit.
I would be very sad if we thought that our Attorney General was bringing a frivolous suit. That is certainly not the will of this legislature. And I will say this, that again, that the goal is to keep cities from using taxpayer funds to transport women out of state for something that is not allowed in Texas.
And I understand that we wish and hope many things, but part of the point of rules is that we establish guidelines that say if something happens, that there is a remedy for it, there is a protection for it, but you're specifically taking that protection out. Correct?
I am keeping my bill as it came from the senator, yes.
And in sub C2, you specifically strike out chapters 27 and 110 of the Civil Practices and Remedies Code. Are you aware of what those chapters do?
I do not have those in front of me.
Okay. Do you know that Chapter 27 of the Texas Civil Practices and Remedies Code is the Texas Anti-SLAPP statute?
Again, I do not have that part of the code in front of me.
Okay. Well, let me help you out just a tiny bit. On Chapter 27, the stated purpose of Chapter 27 is, it says, quote, in statute 27002, the purpose of this chapter is to encourage and safeguard the constitutional rights of persons to petition, speak freely, associate freely, and otherwise participate in government to the maximum extent permitted by law, and at the same time, protect the rights of a person to file meritorious lawsuits for demonstrable injury. This law, if passed, would prohibit the cities from this purpose.
Again, my goal is to have cities comply with the law. Absolutely, they must comply with this law. That is our goal. That is the goal of our legislature every time we pass a law. And yes, that is the goal of this law.
But you're not arguing with me that it doesn't restrict cities from the application of this chapter, right?
I'm going to stay within the four corners of this bill and stick with the wording
Right.
that was sent to me by Senator Campbell.
So the wording of this bill is that cities, if they're sued, may not use protections of personal freedom and public freedom as a defense.
Our goal, once again, is to never have a city be sued because they are so in compliance with this law and other laws of our state.
Are you familiar with Chapter 110 of the Texas Civil Practices and Remedies Code?
Again, I do not have that in front of me.
Do you know that Chapter 110 is called the Religious Freedom Protection Act?
I will take your word for that.
Okay. And you would also deny a city, a defendant, from using that act as protection?
I cannot fathom a time or place where a city would need to use a religious freedom excuse to send women out of state for the purpose of an abortion. I cannot fathom that in Texas.
Well, I mean, but that's why we have robust debates on the floor, because I might bring to you the ideas that other people may not think the same way and have other perspectives. So thank you very much for your answers.
Thank you.
And Mr. Speaker,
Move passage.
Mr. Wu, for what purpose?
I move to reduce to writing all conversations on SB 33 in second and third reading and place in the journal. And I think there's more.
Motion is there objection to the adoption of the motion? Chair says the motion is adopted.